And then the government of Bender State challenged the constitutionality of the bill, and the court held that since the legislature did not follow constitutional provisions, that the bill could not stand, and as such, the court struck it out for being null and void. So when we speak of supremacy of constitution within the Nigerian context, you must know that the convenient starting point, the foundational basis, is found in the constitution itself. From section 1 subsection 1 that says the constitution is supreme and is binding on all persons and authorities in the country. And then to section 1 subsection 3 that says that if there is any other law that is contrary to the provisions of the Constitution, such a law shall be null and void to the extent of its inconsistency. So which means that there is no law that can be inconsistent with the provisions of the Constitution. If there is any law as such, it should be struck out and set aside as null and void. The implication of this is that let the parliament make laws as tall as Mountain Everest. As long as those laws are contrary to the provisions of the Constitution, they shall fall like a pack of cards in a whirlwind, because the Constitution is the fons et origo. It is the uncommanded commander. The Constitution is the number one authority, and every enactment must derive its validity from the Constitution. This is what the concept of constitutional supremacy entails. I must sharply also state that when we talk about constitutional supremacy, it could mean it could take two forms: either substantive supremacy or procedural supremacy. Substantive supremacy has to do with the substance of the Constitution, has to do with the fact that the Constitution has provided for a particular thing, and if there is any act that now provides otherwise, then that particular act will be set aside for violating substantive supremacy of the Constitution. Take, for example, the case of INEC and Musa. In INEC and Musa, the INEC promulgated the Electoral Act, and then they added new requirement because if you check section 222, I believe, of the Constitution, it provided for requirements that any candidate that intends to run under any party must fulfill, the political party as well. And INEC added to these provisions, and then it was challenged, and when INEC added it, it disqualified Musa, and so he challenged the constitutionality of the act in the court, and the court said that where the Constitution has evinced an intention to provide an exhaustive list, no act can purport to take away or add to those lists. So in essence, the court said the Constitution has provided that these are all the requirements that a party or a candidate must fulfill, and that you cannot add to it because the Constitution does not give you the power to do so. And when we speak of procedural supremacy, like the case of AG Benel and AG Federation, it was because the legislature did not follow due procedure. And also, a very important case in procedural supremacy is the case of Inokoju and Adeleke. Inokoju and Adeleke, it was about the impeachment of the Oyo State governor, and the court said they didn't follow due process. Since you didn't follow due process as dictated by the provisions of the Constitution, then it was set aside as null and void. Another important case also on procedural supremacy is the case of AG Lagos and AG Federation. In AG Lagos and AG Federation, we're not talking about the AG Lagos and AG Federation that has to do with the urban and regional planning law, because the urban and regional planning decree. No, we are talking about the one that has to do with the attempt by Lagos State to extend or add to its 20 local government. They created additional local governments. However, they did so within the parameters of what the Constitution said. But there was a particular defect. It's marked of a defect. So it's because the Constitution says after you've done all you've done, the House of Assembly has done all the Constitution has prescribed, then it must be sent to the National Assembly for ratification. But the Lagos State did not do that, and so it was challenged. And when it was challenged, the court said that there is a procedure, and once there is a procedure, then automatically it means that you must follow the procedure. There's a blind fealty and loyalty that you must always accord the Constitution. And as such, the court said all the local government that were added were null and void. Now, please, it is important to understand that the court did not set aside the existing 20 local governments because they were constitutionally made or created, so to say. And that is the reason why you have to understand the purport of Section 1, subsection 3, which says that law shall be void, null and void to the extent of its inconsistency. So you can have an act, and it might be that it is only a single section in that act that is repugnant or inconsistent with the provisions of the Constitution. It doesn't mean that the court is going to then set aside or strike out the whole act. No, it is that section that the court is going, because it is null and void to that extent, as I said, to the extent of its inconsistency. Also, the case of AG Lagos and AG Federation that has to do with the urban and regional planning decree could also be said to be a case on constitutional supremacy. Yes, because the Constitution has provided for 3 lists. Apparently, the Constitution provides for 2 lists, the exclusive list and the concurrent list. And the Constitution says that the exclusive list is simply the items on the exclusive list simply for the federal government to enjoy, and that of the concurrent list simply for the federal government and the states to enjoy. But Section 4, subsection 5 then provides that where there is a conflict between that law of the federal government and that of the state government, the law of the federal government shall prevail. However, in the case of AG Lagos and AG Federation, it had to do with the fact that the federal government made the urban and regional planning decree, and then Lagos State challenges and said that if we look at the items, there are 68 items on the exclusive list, and there is nowhere that urban and regional planning was written there. And the same could also be said of the concurrent list. And so that since nothing is in the exclusive list and in the concurrent list, then it automatically means that that it falls under the residual list. And the court agreed and said what is not in the exclusive list, the concurrent list, will fall in the residual list. And in the residual list, it is the state that can make laws there. So in essence, the court was saying that the Constitution has provided for this, you cannot do otherwise. And that is that for today's class on constitutional supremacy. I remain Ori David, and do not forget to click on the subscribe button if you haven't. Thank you, and once again, happy Easter. I'll see you next time.